SJC-13397, in the matter of Theresa A. Jablonski.
Chief Justice Budd and Associate Justices, may it please the Court. My name is David Levy and I represent the appellants. In 2003, Theresa Jablonski, who was then 77, made a will that left her entire estate to a pet trust for her Cocker Spaniel Licorice. The will also provided that if the pet trust was funded and there was money left over after the last dog died, then the trustees of the pet trust could give the money to a charity of their choice. As it turned out, however...
It's also Article 4, though, right? You want to address Article 4, particularly the express language in that about lapsed devices?
Yes, the problem with Article 4 does not create a freestanding bequest if Article 5 fails, because Article 4 was worded in a particularly restrictive way. It said that if the other bequests lapsed or failed for any reason, then the residue of the estate should go to the trustees of the Licorice Testamentary Trust.
But doesn't that cover even, I mean, okay, so it's clear that the primary concern is her dog, Licorice, but she creates this trust, and she also creates this provision that says if everything lapses, it goes into this trust. So don't we combine those and find that's sufficient to indicate that this trust is created?
No, because the problem is that in that circumstance, the money would be all dressed up with nowhere to go.
Well, I get that this is not her ideal setup, but you know, we've got to try to make sense of this will, and we try to avoid intestacy, right? And you know, Article 4 seems to be enough to save that because it refers to when things lapse.
The problem is its remedy for the lapse is to throw the money back right at the trust that has lapsed. Mm-hmm. That doesn't exist. I want to emphasize the parties have stipulated that if Theresa died without a dog, without a pet, then the Article 5 trust could not come into existence and could not be funded.
Well, I don't know if they've stipulated to that. I mean, we'll hear from her, but I suspect that's not the case.
Oh, I'll give you, Your Honor.
Well, then we wouldn't be here, right?
I'm not sure why we're here, but it was stipulated. There was a statement of uncontested facts in the motion for summary judgment. It's volume 3, page 73 of the joint appendix, and I'm going to quote it because it's a critical thing that we seem to have forgotten. Mm-hmm. Article 5 of the will did not authorize any bequest to the pet trust or the transfer of any funds to its putative trustees if Theresa was predeceased by all of her pets. That stipulation is binding.
Well, then does Article 4, though, kick in then? Because, okay, Article 5 lapse. And then Article 4 says anything that lapses goes into the trust. So I'm not sure that it's inconsistent.
The problem is that it goes into a trust that by parties have stipulated doesn't exist. Well, and can't be funded, and has no purpose. Article 4 standing alone doesn't.
Its purpose is to deal with. I mean, there's no other provision for what happens if. That's the only provision that kicks in if things lapse. There's no alternative beneficiary. There's no, there's nothing else for us to turn to, right?
That's not correct under the precedents of this court. If the bequest lapsed and the residuary clauses lapse, then the estate has to pass through intestacy.
Well, you say that, but on the other end, there's the acceleration provisions. So assume for the sake, I think, that everybody agrees that the trust didn't exist, and so now, where do we go from here? You say it goes to the folks that you represent. There's also the alternative, which is what the trial judge found, was that we can go to the acceleration of remainders provisions that says now this all goes to charity. It's not going to go to your folks anyway. And all of the stuff about the fact that we may not have a trustee named, we might not have specific charities named, the court can appoint folks to effectuate Theresa's wishes.
No, Your Honor, the acceleration of remainders doctrine cannot apply here. And there are two requirements for it that haven't been met here. There have been a few cases in a few states where a pet trust that failed because the pet predeceased the testator triggered acceleration of remainders doctrine to have money give to a charity. But there were two things about it. First of all, in each of those cases, the bequest to the charity was either vested actually or vested virtually. And by vested virtually, I mean that it was a state in which the probate court judges have the authority to construe a discretionary power of appointment as a mandatory one, in effect force the vesting of the gift to the charity. That wasn't the case here.
You're not referring to the Mills estate in this. You're not referring to New York and California when you.
I actually am, and to a handful of other cases. They involved either a vested gift to a charity, or they were a state where the state courts were willing to reconstrue.
You interpret Mills and the California case, I think maybe a state of McNeil, as not standing for the simple proposition that the pet will is invalid, that your Article 4, since it was never funded, doesn't apply.
I'm sorry, I was focusing on the acceleration of remainders issue.
And the accelerate, so is it dependent, though? That was my next point. You're saying that those cases are only analyzing acceleration of remainders and don't have a broader application that when the pet provision is invalid, nonetheless, you can look to the charitable provision and enforce it.
My recollection, and all the cases are cited by the parties, is that the cases were dealing with acceleration of remainders. And there were, to finish answering Justice George's question, there were two elements that were present in those cases that aren't here. One is that the bequest of the charity was vested, which it wasn't here. This was a discretionary power of appointment. And second of all, the remainder bequest to the charity wasn't conditioned on the same non-occurrence that caused the primary bequest to fail or lapse. And neither I nor Judge Moriarty nor my sister counsel have found any case in which acceleration of remainders doctrine was applied when those two elements were missing.
There's not much here. There isn't much here. I mean, we all can agree that there is a dearth of appellate case law here to guide you both or Judge Moriarty. But I think if we zoom out of this, and this is my real concern, there is a clear, whether or not you agree with this, there is a clear indication that it is not to go to your clients. It is to go to the pet trust, which fails, and then in absence of that, any remainder is to go to charity. And that was clear from Theresa that that's where it should go. It should go to the pets, and then it should go to charity.
With all respect, no, it is not clear. Both of those bequests or provisions were conditioned on the survival of Theresa by one or more pets.
Sure,
And
sure.
so she put that
I
condition
hear that,
on it.
but I'm saying, assume for the sake of argument that Licorice survived her or any other pet. You wouldn't be arguing that it's not clear that somebody needs to take care of the pets, and then once the pets die, it goes to charity.
That's absolutely correct.
Okay, so assume for the sake of argument now we take away that first layer, in that everybody agrees that the trust fails. Why doesn't part 2 still stand, that it's to go to charity?
because the bequest was conditioned on the survival of the pet, this puts this case in the same shoes as Bray v. Bray and the other cases we cited, where a bequest was conditioned on an event that didn't happen, and the parties who wanted the bequest to be given anyway, even though the condition wasn't met, said, well, gosh, you got to look at the underlying intention of the testator. In Bray v. Bray, which I think is on point, the husband left all of his estate to his wife if she survived him, and specifically disinherited his sister. And that's a stronger case than this one, where the testator refused to put in a specific disinheritance clause. Well, it turned out the wife predeceased the husband, and the court held that the estate had to pass through intestacy. Some other kin argued, well, even though the bequest failed, the fact that there was language in there disinheriting a sister, that shows an underlying intent to disinherit the sister, so she should be excluded from the intestate share. And this court rejected that argument, saying that you've got to apply the plain meaning of the will, and you cannot speculate about the testator's intentions about what she would have done in a scenario that didn't happen. I want to remind Your Honor that this will could have been written in a way that we wouldn't be here today. If she had written a will, if Attorney Tupper, who was
I thought it was written that way, and that you said that there was a stipulation and we shouldn't be here anyway.
it was written the opposite way.
So the
Okay,
stipulation brought you out of that.
The stipulation by the parties and the concession by my...
And one thing I would just like to clear up and make clear is that this argument on both sides and this trust, it stands in the same position it would as if it had been left to a human being. Is that correct?
Yes, because the effect of the pet trust statute is to substitute an animal life for a pet life. So you're still applying the same, by analogy, the same common law precedents that were not overridden by the Uniform Trust Code. I'm sorry, I've lost track
Can I ask you a different question about when the trust, in 2003, did the trust come into being and it was just an unfunded trust?
No, because the trust was a testamentary trust, not an inter vivos or living trust. So it was not contemplated that it would come into effect until Theresa died. I've lost track of the question that was...
I want to, before we lose you, I just want to understand where you are. You've dropped the undue, you're not pursuing undue influence, but you're focusing in on the fact that you were not given discovery on the gifts to Anne. So what are you arguing on that point?
Okay, that's a separate issue.
I know it's a separate issue, but it's part of the case. So.
Okay, I'll be happy to respond to that. On that, which is Roman 3 of our opening brief, we're arguing that my clients believe that Anne, the appellee, diverted assets of the decedent during the last 16 years of her life.
Right, but
we have two grievances. One of them is for the period 2003 to 2011, right, where the money
I get it, but I'm trying to understand what that So the trial judge rules, she limits your discovery, or he limits your discovery.
She barred discovery for the period before 2011.
But you're not making an undue influence argument.
No, it's not.
So what is it? What is the relevancy of the discovery you were not given if it's not that she asserted that she diverted monies? I'm trying to understand.
Why are we aggrieved, in effect, when we're not arguing undue influence?
Yeah.
We're aggrieved because the judge on that issue reached the merits of the diversion issue by saying we didn't meet our burden of proof after having denied discovery. If the judge had simply said, this was an element of undue influence, you're dropping undue influence, why a rule against undue influence on other grounds, and therefore I'm not going to reach the issue of diversion of assets. That's an issue for you or for the executor of the estate to pursue once an executor is appointed. That we would have no beef because we wouldn't be aggrieved. The issue would be preserved.
Tell me what your remaining beef is, because the judge makes findings. She says the annuities are fine because she wasn't present with the stockbroker, so the annuities are fine, and the judge cut you limited discovery to 5 years, including 2 years before the will, all of which seems reasonable to me, but you're saying something's wrong, but you're not making an undue influence argument. So I'm just trying to, what is it you're asking us
It's
to do on that?
prejudging with prejudice an issue that we would otherwise be able to pursue if we have standing as heirs at law. We could then go to the executor of the estate and say, we want you to pursue a claim against Ann Jablonski for improperly taking the woman's assets.
All right, okay, I now understand.
And at that point, it could be tried. But that has been prejudged because the judge has reached a ruling on the merits of that issue without giving us a chance of discovery. If the judge had simply said, this is off the table, I'm rejecting undue influence on other grounds, so I'm not going to reach the merits of that, we wouldn't be aggrieved.
Okay, any other questions? Thank
Thank
you
you.
very much. Okay, Attorney Capiwala.
On my papers. Good morning, Chief Justice and Justices. Penelope Cathawala for the appellee Ann Jablonski, who was the appointed, currently was appointed the personal representative of Theresa Jablonski's estate.
Can you address the stipulation before we go any further?
Well, I was not present at that hearing, and that stipulation, I think, was from Attorney Tupper's point of view, when I did speak with him about that, in his mind, did not relate to the entirety of the case. He was suggesting that, which I believe Judge Moriarty found, that that the Licorice, the dog, was not alive at the time of Miss Jablonski's death. I think that was the stipulation he was trying to convey, and that, yes, that provision, at least, since there was no dog alive and she died after the dog, that provision at least would somewhat lapse.
What is that provision? Article 5?
Yes, Article 5 is the trust.
Yeah.
Article 4 is the,
So Article 5 lapse is stipulated by your client.
the Article 5, that a portion of that lapses, meaning that there was no dog surviving, either Licorice or any other dog, at the time of her death.
What
So,
does that mean then? So if it lapses, what's alive?
I'm suggesting to the court that what is alive as a result of number 4 is the intent of the testatrix to leave all her.
You say number 4, or number 5. Are you saying because of Article 4 it stays, even though 5 lapses, 4 saves it, Article 4 saves it, or what are you saying? Because this is kind of a mess.
It is a mess. And I'm certain I could suggest that this could have been a little bit more artfully drawn.
Oh, I'd say
this
a lot
will.
more artfully drawn.
Especially, you generally would have seen Article 4, probably Article 6, in my mind, just for
But
start.
just help us out here, because I am confused by the same question Justice Wendland asked, which is, if Article 5, I thought Article 4 kept everything alive, but if this, is that consistent with the stipulation or not?
I believe Article 4 is a residuary clause intending that, relating back to that charity should receive these monies. And I guess I would suggest to the court, I wouldn't guess, I'm asking the court to, number 1, first rule of construction, what is, or rule of law, what is the intent?
Well, I'm trying to figure out what the intent is, because the clear intent here is, okay, the most important creature in her life is Licorice, and I get that. And she wants to make sure that Licorice is taken care of, and that the people who take care of Licorice are the people she's going to trust the most.
Yes.
But once Licorice dies, those people don't exist. And also, she doesn't care about any particular charity. This isn't like, if Licorice dies, I want this to go to an animal shelter. There's none of that. We've got this kind of amorphous gift to charity in general, but she doesn't have any interest in it when this is done. And we've got concessions from the lawyer who drafted it that it was about licorice, that's it, right? So I'm trying to figure out, are we rewriting the will or are we following the will here?
Add
I
to
would
that whole equation that I think the attorney said that she didn't want to put anything in the will to disinherit.
That's correct. So I'm sure you have long ago read the 3-day trial, and you would have learned from Attorney Tupper and I believe Mr. Jablonski as well, that Theresa, she was a daily communicant at church, lived near the church. She was somebody, I would suggest, who didn't have a lot of friends, but went
But
to
she doesn't give the money to the church.
Right.
She doesn't give.
She wanted it to go to a charity, and she did
No,
not.
she doesn't really. She wants it to go to a charity designated by the people who are going to take care of licorice, right? That it's a little different, right?
Right.
Yeah, yeah.
And you're suggesting perhaps it could be a power of appointment. I don't think it was found, but that was a power of appointment that then failed. I
Don't we
guess
have a level of ambiguity? As you just admitted, it's a mess.
This,
So given the 3-day trial, the fact that she didn't want to expressly disinherit her human family, don't we need to take all that into account, which is not what the judge did below?
well, I think that a reading of the transcript and a reading of some of the other documents that are in the appendix would clearly indicate, number one, she did not want to disinherit anyone. Well, by leaving to charity, she was disinheriting, but she did not want to say that. And I think Attorney Tupper testified about that in the portion of the trial which was on
So
undue
before you
influence.
go into the factual dispute, are you admitting then that the will itself is not capable of divining her intent? That we need to go into the extrinsic evidence to figure out what it is that she intended?
I'm not admitting to that. I believe that she had every intent to, and again, recall she had been in rehab, broke her leg.
No,
was-
but that's,
right,
again, you're going
okay.
into the factual record. I'm trying to figure out if your position is, as the judge found below, that the will itself is enough. The 4 corners of this will is what we look at, and these words are crystal clear that she wanted just to establish this licorice trust and then require whoever the trustee was, who's again not named, to put all of her assets into a yet-to-be-named charity. And that's crystal clear in your view from the
I'm
will.
suggesting that is, from my reading of it, and from trying to glean, and going back, this is not a person who said, I don't care what happens, I just want my dog taken care of. This is a person who hired a lawyer, wrote a will, wanted her dog specifically taken care of in that will, and then thereafter to leave the proceeds of her residuary estate to a charity. I think that was the intent of Ms. Jablonski when she took a number of steps, called a lawyer, went to a lawyer, had a will drafted, came back, signed it. I mean, if it was all just like, why don't I just leave a few dollars somewhere and the dog will be fine and I don't care what happens, I don't think that was her intent.
Yeah, but again, you're going into the factual record and
Right, exactly. I mean, I don't think that her, what I would suggest is her intent should be thwarted by an artfully drawn, let's say, testamentary trust for a pet, which, as you recall, that was a brand-new statute that had just come out during the time she was, just a little before, she wrote that will in 2013. So I'm also suggesting there could have been some inartfulness in the drafting because there wasn't a lot of what I would call boilerplate language for attorneys to follow at that time. And I believe there hasn't been any, to date, any case law on these pet trusts here.
Yeah, but again, you're pointing to things outside the outside the will in
Yes.
order for us to construe it. And when you do that, you can't just do what came before, the fact that she hired a lawyer. It also goes to what came after, and all the evidence that she told the attorney that she didn't want to expressly disinherit her family.
Counsel, can I ask you a question that goes back to something that Attorney Levy mentioned? What in least, I didn't get this from the briefing, but perhaps you could tell me. What does Massachusetts tell us about what you have to demonstrate in order for the acceleration of remainders to obtain? Counsel said there's two things that need to be demonstrated here that we have in the New York case and the California case that we don't have here. Do you agree with what those two things are? And if you are, what are they?
Well, I believe that, number one, we do have case law in Massachusetts on acceleration of remainders.
Sure,
And
but
that-
what does it tell us we need? That we will need to find whether or not it's applicable in this
I think you need
case?
a trust to terminate in some way, and simply once it's terminated, you can accelerate the remainder, and especially so if it's to a charity, which of course the courts favor. So that is where I believe, that is what I believe is the only requirement.
That the acceleration be to a charity?
I didn't get that, Judge?
I guess I'm trying to, and I'm sorry, Justice George, but what are the prerequisites in Massachusetts in order to accelerate a remainder? That it be a trust and that the remainder go to charity? It seems like that was your answer, but I'm pushing back on that because I can't find any case law to that effect.
On acceleration of remainders?
Yeah, what is the
because we-
prerequisite in Massachusetts for that doctrine to apply?
I believe Judge Moriarty said, I'm not sure, I think it's in my brief too.
Not in the decision, I can tell you that much.
I didn't hear that, Judge.
It's not in the decision, it's not in Judge Moriarty's decision. Because if we take the first one, using the more artful way that Justice Wendland put it, the prerequisite, you said the first is the termination of the trust, even if there was no trust here.
Right. Well, and/or I'm just saying, any provision in the will that fails in some way. And there is a remainder
Okay.
that it's to go to can then be accelerated. I'm just suggesting there were two cases where there were exactly these particular kinds of trusts set up, and that's the New York and the California McNeil case and the,
Mills.
yes.
Do we even need it? I mean, I thought, doesn't Article 4 make the acceleration of remainders unnecessary? Article 4 tells us what to do. Why isn't the four corners of the will, basically, you can read it with Article 4 to say that when it lapses, it goes to this trust. Isn't that a simpler way for you to get to where you want to go? What's wrong with that? Tell me.
Well, I don't think there's anything wrong with that, other than it, again.
Judge relies on she brings up Article 4, she combines it with the acceleration, but I don't even know if there's an acceleration going on here, because Article 4 says if anything lapses, the money goes to this trust, and then there's the power of this trust to distribute to charity. I just don't know why that doesn't work. Is the case that simple?
May I add to Justice Kafker's point, because I don't see it that simply, so if you could address this. Because back to Attorney Levy's point, it can't go back to nothing. So if there's no Article 4, if you could tell me if it still is applicable, if there isn't a trust. If there's no trust, would Article 4 still be applicable?
Well, if you, yes, well, I don't want to essentially admit to, or I don't agree with that. The clear reading of that says, I think I would rather go back to the intent. Whatever isn't used for the dog goes into that residuary remainder section of the pet trust in this will that says it goes to charity.
But the
And a lot of circular
But it was-
reasoning.
Yeah, it's a big do-si-do, right?
It is.
And it's also explicitly dependent on the charitable portion being funded, because the trust went into effect because the pet survived the testator.
Well, again, there's been, and I believe, again, Judge Moriarty addresses that, there's no case law addressing in our state whether a remainder gift to an unnamed charity is vested. But then she cites the Lichter case in Trust Company of New York, and, I'm sorry, that's of New Jersey. And then Leo's case, which is the New York case. Again, she cites those and says, well, even though there's charitable remainders, they're not vested in a charity, they still can be valid. And so our state has not said anything about that yet, but she refers to that Lichter case that is in her motion to reconsider memoranda, as well as Leo's case. So that's New York and New Jersey. And then, of course, she refers to the other cases, McNeil case, and I keep forgetting that's another Irish name. I did cite them. The California and the,
Both of those cases, right, the remainder, the trust is an animal charity, right? Or am I misremembering?
No, you're right.
So it makes sense.
Right.
She's an animal person, and it goes to an animal, but charity. But this is, here we just got an open-ended, and also, it's not even people we know. It's the court is going to decide on its own, whatever charity it likes,
yes.
give it away.
And that
Isn't
was
that
a-
inconsistent with our case law a little bit, that it's too open-ended?
Well, we don't have that case law of an unvested remainder. Yeah, I mean, the court has not spoken about that. And as I said, Judge Moriarty referred to those two cases, the Leo's case, that's New York, and the Lichter case, which is New Jersey. Again, a well-thought-out decision on her reconsideration memo of the partial summary judgment.
Counsel, I have one question to follow up on Justice Kafker's earlier question about Article 4.
Yes.
Which is that the lapsed gifts go to the Licorice Trust. One of the things that the judge below says is that that's not enough to save the bequest. Do you have an explanation for that statement? Why it's not enough? Article 4 in and of itself is not enough to save it?
I think she was referring to, excuse me, or I'm suggesting she was referring to the lapsed provision that
Right, and she says that's
just-
not enough to save.
the partial I'm suggesting to you that she is
She says
stating.
it's not enough to avoid intestacy. It's okay if you don't know. I just wondered. This is my opportunity to ask you.
Yeah, I'm not sure I saw that, because at the end, again, she says she finds that the gift is vested in charity. And again, that's in her memoranda. And she refers again, as I said, to other states, because some of we don't have case law on that. Not only on the pet trust in general, because that was done when it just came out, and again, the issue of whether a remainder to an unnamed charity is vested. We don't have any case law on that.